Yoboseo. Always check description for more details. Averments in pleadings which are not deemed admissions. There are averments in the pleadings which are not deemed admitted even if the adverse party fails to make a specific denial of the same, like immaterial allegations, Sec. 11 Rule 8, Rules of Court, conclusions, non-ultimate facts in the pleading, Sec. 1, Rule 8, Rules of Court, as well as the amount of unliquidated damages, Sec. 11 Rule 8, Rules of Court. Implied admissions of allegations of usury. Under Sec. 11 of Rule 8, if the complaint makes an allegation of usury to recover usurious interest, the defendant must not only specifically deny the same but must, likewise, do so under oath. Failure to make the proper denial under oath would involve an implied admission of the allegation of usury. Implied admissions of actionable documents. 1. When an action or defense is founded upon a written instrument, the genuineness and due execution of the same instrument shall be deemed admitted unless the adverse party, under oath, specifically denies them and sets forth what he claims to be the facts. Sec. 8 Rule 8, Rules of Court, Philippine National Bank v. Refrigeration Industries, Inc., 479 SCRA 240. 2. The failure to deny the genuineness and due execution of an actionable document does not preclude a party from arguing against the document by evidence of fraud, mistake, compromise, payment, statute of limitations, estoppel, and want of consideration. Actionable v. Actionable, 454 SCRA 555, Philippine National Bank v. Refrigeration Industries, Inc., 479 SCRA 240. He is, however, precluded from arguing that the document is a forgery because the genuineness of the document has been impliedly admitted by his failure to deny the same under oath. Admissions in the pre-trial of civil cases. 1. One of the purposes of a pre-trial in a civil case is for the court to consider the possibility of obtaining stipulations or admissions of facts. Sec. 2d, Rule 18, Rules of Court. A pre-trial is mandatory. Sec. 2 Rule 18, Rules of Court, and because it is mandatory, it is an important part of a civil proceeding. Admissions, therefore, in the pre-trial, as well as those made during the depositions, interrogatories or requests for admission, are all deemed judicial admissions because they are made in the course of the proceedings of the case. 2. Admissions made in a stipulation of facts by the parties in the pre-trial are treated as judicial admissions. Eastern Shipping Lines, Inc. v. BPI, MS Insurance Corporation, GR number 182684, January 12, 2015. For instance, petitioner's admission as to the execution of the promissory note at the pre-trial sufficed to settle the question of the genuineness of the signatures therein. The admission, having been made in a stipulation of facts at pre-trial by the parties, must be treated as a judicial admission. SCC Chemicals Corporation v. Court of Appeals, 353 SCRA 70. Admissions in the pre-trial of criminal cases, Bar 2008. 1. Although an admission made during the pre-trial is deemed to have been made in the course of a judicial proceeding and is necessarily a judicial admission, an admission made by the accused in the pre-trial of a criminal case is not necessarily admissible against him. To be admissible, the conditions set forth by Sec. 2 of Rule 118 must be complied with. The pertinent rule provides, SEC. 2. Pre-trial agreement. All agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel, otherwise, they cannot be used against the accused. 2. Does the above rule, requiring an admission made or entered into during the pre-trial conference be reduced in writing and signed by the accused and his counsel before the same may be used in evidence against the accused, equally apply to stipulation of facts made during the trial? In resolving the question in the negative, the Supreme Court ruled, a stipulation of facts entered into by the prosecution and defense counsel during trial in open court is automatically reduced in writing and contained in the official transcript of proceedings had in court. The conformity of the accused in the form of his signature affixed thereto is unnecessary in view of the fact that an attorney who is employed to manage a party's conduct of a lawsuit has prima facie authority to make relevant admissions by pleadings, by oral or written stipulation, which, unless allowed to be withdrawn, are conclusive. In fact, judicial admissions are frequently those of counsel or of the attorney of record, who is, for the purpose of the trial, the agent of his client. When such admissions are made, they bind the client. People v. Hernandez, 206 SCRA 25, Sillet v. De La Rosa, 543 SCRA 533. Implied admissions in the modes of discovery, bar 1984. 1. Admissions obtained through depositions, written interrogatories or requests for admission are also considered judicial admissions. Program Incorporated v. Province of Bataan, 492 SCRA 529. The filing of written interrogatories under Rule 25 and request for admission by adverse party under Rule 26 is mandatory in civil cases. Within 1 day from the receipt of the complaint, aside from the preparation of the required summons, the court shall issue an order requiring the parties to avail of Rules 25 and 26 I.2 am. No. 03-109 SC, July 13, 2004. 2. Under Sec. 1 of Rule 26 of the Rules of Court, a party may, at any time after the issues have been joined, file and serve upon any other party a written request, for admission by the latter of the genuineness of any material and document described in and exhibited with the request. The request for admission may also be of truth of any material and relevant matter of fact set in the request. The party to whom the request is directed must file and serve, upon the party requesting the admission, a sworn statement either denying specifically the matters of which an admission is requested or setting forth in detail the reasons why he cannot truthfully either admit or deny those matters. The sworn statement must be filed and served within the period designated in the request, which shall not be less than 15 days after service thereof, or within such further time as the court may allow on motion. If the sworn statement required is not filed and served, each of the matters of which an admission is requested shall be deemed admitted. Sec. 2, Rule 26, Rules of Court. 3. Under Sec. 3 of Rule 26, any admission made pursuant to the request for admission is for the purpose of the pending action only. The admission shall not be considered as one for any other purpose, nor may the same be used against him in any other proceeding. Admissions in amended pleadings, bar 2011. When a pleading is amended, the amended pleading supersedes the pleading that it amends, and the admissions in the superseded pleading may be received in evidence against the pleader. Sec. 8 Rule 10, Rules of Court. Nature of admissions in superseded pleadings. It has been held that the admissions in a superseded pleading are to be considered as extrajudicial admissions which must be proven. The Supreme Court declared that pleadings that have been amended disappear from the record, lose their status as pleadings, and cease to be judicial admissions, and to be utilized as extrajudicial admissions they must, in order to have such effect, be formally offered in evidence. Torres v. Court of Appeals, 131 SCRA 24. Admissions in dismissed pleadings. Admissions made in pleadings that have been dismissed are merely extrajudicial admissions. Service-wide Specialists, Inc. v. Court of Appeals, 257 SCRA 643. Sworn statement of a proposed state witness. If the motion to discharge an accused as a state witness is denied, his sworn statement, submitted to support the motion, shall be inadmissible in evidence. Sec. 17 Rule 119, Rules of Court. Admissions by counsel. Admissions by a counsel are generally conclusive upon a client. De Garcia v. Court of Appeals, 37 SCRA 129. Even the negligence of counsel binds the client. Saraga v. Banco Filipino Savings and Mortgage Bank, 393 SCRA 566. This rule is not, however, without exception. In cases where reckless or gross negligence of counsel deprives the client of due process of law, or when its application will result in outright deprivation of the client's liberty or property, or when the interests of justice so require, relief is accorded the client who suffered by reason of the lawyer's gross or palpable mistake or negligence. Salazar v. Court of Appeals, 376 SCRA 459. Effect of judicial admissions. 1. Judicial admissions are legally binding on the party making the admissions. Noyne v. City Homes Builder and Development, Inc., 735 SCRA 708. It is an established principle that judicial admissions cannot be contradicted by the admitter who is the party himself and binds the person who makes the same, absent any showing that this was made through palpable mistake. No amount of rationalization can offset it. Commissioner of Internal Revenue v. Manila Electric Company IMERALCOI, General No. .181459, June 9, 2014. A party who judicially admits a fact cannot later challenge that fact, as judicial admissions are a waiver of proof, production of evidence is dispensed with. A judicial admission removes the admitted fact from the field of controversy. Consequently, an admission made in the pleadings cannot be controverted by the party making such admission, and is conclusive to such party, and all proofs to the contrary or inconsistent therewith should be ignored, whether objection is interposed or not. The allegations, statements or admissions contained in a pleading are conclusive as against the pleader. A party cannot subsequently take a position contrary to or inconsistent with what was pleaded. Eastern Shipping Lines, Inc. v. BPI, MS Insurance Corporation, GR number 182864, January 12, 2015. The reason for the above rulings is found under the doctrine of estoppel. Under the doctrine, an admission or representation is rendered conclusive upon the person making it, and cannot be denied or disproved as against the person relying thereon. Manzanilla v. Waterfields Industrial Corporation, GR number 177484, July 18, 2014. 2. The trial court may reject evidence that a party adduces to contradict a judicial admission he made in his pleading since such admission is conclusive as to him. Equitable Card Network, Inc. v. Capistrano, 665 SCRA 454, 465, February 8, 2012. The judicial admission removes an admitted fact from the field of controversy. Josefa v. Manila Electric Company, CR number 182705, July 18, 2014. 3. No evidence is needed to prove a judicial admission, and it cannot be contradicted unless it is shown to have been made through palpable mistake or that no such admission was made. Arroyo Jr. v. Tedoran, 421 SCRA 423. But despite the presence of judicial admissions in a party's pleading, the trial court is still given leeway to consider other evidence presented. Santos v. Lumbao, 519 SCRA 408, citing Atillo v. Court of Appeals, 266 SCRA 596, winking face, because said admissions may not necessarily prevail over documentary evidence. ASEAN Pacific Planners v. City of Urdaneta, 566 SCRA 219. 4. Specifically, under Sec. 4, Rule 129 of the Rules of Court, the following are the effects of judicial admissions. A. They do not require proof, and b. They cannot be contradicted because they are conclusive upon the party making it. How judicial admissions may be contradicted. 1. Sec. 4 of Rule 129 provides for either of two ways to contradict a judicial admission, namely a. By showing that the admission was made through palpable mistake, or b. By showing that no such admission was made. The mistake that would relieve a party from the effects of his admission is not any mistake. It must be one that is palpable, a mistake that is clear to the mind or plain to see. New Oxford American Dictionary, 2001 ed. p. 1232. It is a mistake that is readily perceived by the senses or the mind. Oxford English Reference, 2nd edition, revised, 2002, p.1049. 2. A party may also argue that he made no such admission. This argument may be invoked when the statement of a party is taken out of context or that his statement was made not in the sense it is made to appear by the other party. Here, the party upon whom the admission is imputed does not deny making a statement. What he denies is the meaning attached to his statement, a meaning made to appear by the adverse party as an admission. The Committee on the Revision of the Rules of Court explained the second exception in this wise: if a party invokes an admission by an adverse party, but cites the admission out of context, then the such admission, or that his admission was taken out of context. That the party can also show that he made no such admission, i.e., not in the sense that the admission is made to appear. That is the reason for the modifier such, because if the rule simply states that the admission may be contradicted by showing that no admission was made, the rule would not really be providing for a contradiction of the admission but just a denial. Atillo v. Court of Appeals, 266 SCRA 596, Sikkim v. Jorge, 529 SCRA 443. End of Chapter 3. See you next slide. Gamsahabnida.